Good morning, everyone. I hope everyone's doing well today. Welcome to our monthly compliance seminar. Let me just get our computer going here. I'm Ann Lavelle. I'm the compliance specialist for CTR. Prior to working with CTR, I spent a couple of decades practicing management side labor and employment law and exclusively represented employers when they had labor and employment problems with their employees. I no longer practice law. I've retired to spend more time with my family, but I always really enjoyed the training component of it. So I'm very happy to be able to do this. I think we're going to have some fun today, which maybe shows that I have a warped sense of what's fun. But I think it'll be interesting to discuss our topic today, which is EEOC. That's the Equal Employment Opportunity Commission complaints and investigations. We always set these up so that at the beginning of the seminar, we talk a little bit about any legislative update that might be out there that's affecting folks. This affects folks in Florida. First and foremost, of course, my thoughts and prayers are with everybody who has sustained damage because of Hurricane Ivan down there. I hope that everybody is doing well and that things are starting to get back to normal. The IRS is showing a little compassion, and they have issued some tax relief for folks in Florida who are affected by the hurricane. And the relief is basically extensions. So if you already had an extension in place for anything that was due on October 17th, that's when the old extension would have expired or will expire next week. You now have until February 15th to file. The same is true for your quarterly estimated tax payments that would be due on January 17th. You now have until February 15th. The quarterly payroll and excise tax returns that would normally be due on October 31st and January 31st are now due February 15th. So there's a theme here. February 15th is sort of the extension for everything. So if you're in Florida and you're affected by this, let us know. CTR can help you with these extensions, and it gives you a little bit of relief and breathing room while you take care of far more important things. All right, turning to the topic at hand today, and for those of you who have attended our seminars before, we usually do this on the second Thursday of every month, like today. And I love to answer questions. It makes it a better learning experience for everybody. It makes it more fun. Of course, I've already told you we're going to have lots of fun today with the topic of the EEOC. Again, I know most of you are questioning my life at the moment that I think this is fun, but please use the chat or the Q&A. I check both of them and ask any questions that you may have as we go through this. Dealing with the EEOC or the related state or local agencies for complaints of discrimination is something that darkens just about every employer's doorstep. We're going to go over some of the situations that happen in real life when I practiced, although I've changed the names and some of the minor facts to provide anonymity to the employers that were involved. And we'll talk about how this process works. So if this does darken your doorstep, hopefully it won't be as alarming, because it often is alarming to employers. And we'll talk about how the process works so that you know what to expect and how it's working and just the timetable that you might be on with something of this. So let's set a little backdrop here. All of you who deal with HR have a Janet in your life. I am certain of that. Janet's an attitude problem. She's actually a good performer, but she's an attitude problem. And she has been since the day you hired her. You can raise your hand if you have a Janet in your workplace, but you don't have to. It's the last track. I see a couple of hands raised. I appreciate that. You're very honest, because everybody has a Janet. And the law firm I worked for had several hundred attorneys. I was a partner there. We had Janets. It just happens. They're in the workplace. So it's the last straw. Janet's been around for several years. Her supervisor shouts at Janet that she, the supervisor, is going to have HR fire her. And we'll talk about why this all happened a little bit later. Janet says She quits because she can't stand the supervisor, and her parting words as she storms out of the building are, "I'll see you in court. You can't treat me like this." Sort of like Perry Mason in the workplace here. She may have also included a few colorful metaphors in her departing speech, but this is a family program, so we'll leave those out. Heck, she watches TV ads. She can find a good attorney. We've all seen the ads, right? Everybody also seems to have a cousin or a sister-in-law or brother-in-law who's also an attorney. Coworkers have popped popcorn and watched this whole thing play out. It's been the gossip for the rest of the afternoon. The HR manager made a critical mistake here. She actually had the gall to take a lunch that day and missed all of this. So she doesn't hear about it until after the dust is settled and the popcorn is all gone. She doesn't even get the popcorn. In fact, when she finds out about it, the supervisor says, "Great news." Again, it's a family program, so we'll leave out the exact reference to the former employee. "Is gone. She said she'd see us in court, and I told her to go for it. I ain't afraid of her." The supervisor, of course, isn't paying the legal bill. So here's the first question. Will the employer see her in court? She quit. Does she even have a legal leg to stand on? Well, let's start with these concepts, because I think sometimes some very basic things that are in the law are not known to employers out there. So the first is, it's completely irrelevant whether she was fired or quit. And certainly in this factual scenario, it's a little bit murky, right? The supervisor is threatened to go to HR to have her fired. She walks off. But let's just say it was clear cut that she walked off the job and said she was quitting. In the law, in employment law, there's the concept of constructive discharge. So it doesn't matter that she quit. What she will argue is she had to quit, that any reasonable person would have quit in her circumstances because the treatment that she received at the hands of her supervisor and probably the rest of the employer was so onerous that she had no choice but to quit. So she was constructively fired. You guys created such a hostile work environment. It was so bad that she had to leave. So the first thing to always keep in mind is when an employee leaves, it doesn't matter if they've left voluntarily, that they quit and walked off the job, or whether it was involuntary, that you actually pulled the trigger and fired them. Either way, they still have the absolute right to proceed with a complaint of discrimination. The next thing that I often heard from employers after we got past the fact that she had walked off the job was, "It's frivolous. This is a frivolous lawsuit." And if the employer has been proactive, if they think they have a hot potato and they've called their counsel before they've even received a complaint, it's kind of nice because you can cloak the conversation in the attorney-client privilege and have a very frank discussion about what has happened, what's gone right, what's gone wrong. Oftentimes I would hear, you got to stop this lawsuit from happening. You got to make it so she can't do anything. The other reality that everybody should appreciate out there is frivolous lawsuits are filed every day. And this may or may not be a frivolous lawsuit. We'll talk more about Janet and her problems. But saying, "I don't want this to come back to haunt me," or "I don't want to have a problem out of this," that's really the wrong questions to ask and the wrong lens to look at this through. The question is not, how do we stop the problem or how do we prevent a lawsuit? You're not going to, and you never will. And if somebody tells you something to the contrary, they're lying to you. You can't stop a train. You can't stop a lawsuit. What you can ask and what you should ask, and the lens that you should look at this through, is, do you have a good defense? And in practicing for more than 2 decades, there is no perfect defense. I guarantee you that you have problems, even if you have the best defense in the world. There's going to be a couple of facts that don't go in your favor. And that's okay. That doesn't mean that you don't fire somebody. I'm a firm believer that you don't allow an employer to handcuff you in your decision-making just because they're rattling their chains about some type of discrimination lawsuit. You do what is right and ethically right and right according to your policies, and you look at, have you defensively positioned yourself well? And then the second question, and I harp on this at every seminar, so some of you are going to be like, oh no, she's on her soapbox again, is, do you have a safety net or the financial wherewithal to handle a lawsuit? The safety net is employment practices liability insurance. Most companies carry it or should carry it. If they're not, it covers complaints of discrimination. So that when you're looking at a situation like this and trying to assess your risk, you're looking at, do you have a good defense? And do you have that safety net? What's your deductible? Is it 10,000? Is it 15,000? What is it? And know that you've got that safety net, that if that person turns around, it's not and sues you, it's not a bet the farm or bet the business type of situation. It is one that's a headache and it's your deductible on the line, but ultimately the insurer is paying the legal fees. And legal fees to take a case to trial, and admittedly almost no cases go to trial, is well over 6 figures. That's just your legal fees. Even one that settles out early, and by early, I mean you're only a couple months into it, you're going to be in the 5 figures. So if you are on the fence about EPLI and thinking about it, it's worth its weight in gold when you have somebody like Janet that you say, gosh, we either made the right decision or we will make the right decision and fire her or whatever it is. And we've positioned ourselves well, and we've got the safety net for us. If we have no insurance safety net, then we have to be a really big company that has the financial wherewithal to say, we can invest 6 figures in defending something, and we're not going to roll over for an employee who doesn't deserve some type of payout. You know, if we haven't done anything wrong, we're not going to pay out. The other thing I used to hear a lot is, she can't afford an attorney and no one will take her case. You can raise your hand again if you think she can find an attorney, because she can. It's pretty easy. There's lots of attorneys out there that do this on the plaintiff side or employee side. And this is what we call a fee shifting statute. So if somebody files a complaint of discrimination against you, it shifts the burden of the attorney's fees if that person is successful in their lawsuit, so that you, the employer, pay the employee's attorney fees. She's not paying anything. This is just like a personal injury case where they take it on a contingency fee case. She's not paying her attorney anything. There's lots of attorneys who will take these cases. And at the end of the day, if she is successful, you pay not just for your attorney's fees, you pay for hers as well too. It's a fee shifting statute. So whatever you're paying your attorney that you may think is exorbitant, you should double that, because you're going to pay her fees as well if she's successful. At the end of the day though, Janet is wrong. She's not going to see you in court, at least not yet. And that's because a prerequisite to filing a lawsuit involving discrimination is filing what we call a complaint of discrimination with a federal or state or local agency. So she cannot run to the courthouse right away. She has to go through this administrative agency prerequisite before she is allowed to sue. In the federal agency level, it's the Equal Employment Opportunity Commission, the EEOC. Here in Pennsylvania, at the state level, the agency is the Pennsylvania Human Relations Commission. If you're in the city of Pittsburgh or Allegheny County, they both have their own commissions as well. If you're located in Florida or Ohio, the same thing is true as well. There's a state agency, there's the federal agency, and some localities have their own local agency. She's free to pick whatever agency she wants. And there can sometimes be some strategy as to which one she picks. Sometimes she just stumbles into whichever one she finds first. And sometimes if she has counsel, they'll direct her to a specific agency, perhaps because that agency has a reputation for being more employee friendly, or sometimes because that agency moves quicker or slower, depending on what they want, than the other agencies. So you can get a complaint from the federal agency, the state agency, or the local agency. It'll come from one of them. How long does the employee have to file? So Janet just stormed out. She's on the clock to file this, but it's a really long clock. It's what we call a statute of limitations. At the federal level, it's usually 300 days. So that's about a year. At the state level, it's like 2 years, at least in Pennsylvania. So she's got quite a bit of time to sit around, think about life, maybe find a job, maybe not. Retain an attorney, talk to that attorney. She's got lots of time. It's not a rush. What does that mean to you? Because you're sort of, you don't control the timeline here at all. It's sort of, you're beholden to whatever she does. You are in a defensive posture, not in you're controlling. So the first thing you should know is if somebody has threatened to sue you, whether it's an employment law or anything else, you have an affirmative obligation to preserve any and all documents related to the matter. So even if you're not sure she's going to follow through with the threat, this includes electronic documents. So some documents are obvious, right? Her employee file would be something that you would preserve. You don't just throw that out since she's gone. Emails, those may be relevant. You're going to save any company emails. What is more difficult, though, is lots of places have their employees using their own devices for work-related matters. So you may need to preserve documents that are actually like emails or text messages that are on somebody's private phone. And that becomes difficult to do. Sometimes you have to send out a communication to individuals who might be relevant and involved, like Janet's supervisor, and say, hey, you can't destroy what's on your phone if it relates to Janet. You have to preserve everything. We can help you preserve it, but you can't just go and drop your phone in the lake or something. It doesn't work that way. Excuse me. If you fail to preserve evidence, right? This is before you have even been sued, before you've gotten anything. You just have a threat on your hands. You need to take reasonable steps to preserve the evidence, which if you haven't done that, you haven't preserved it, the parade of evils that happens is that the court looks at it and says, gosh, you should have preserved stuff. You knew there was a risk of litigation. You didn't do it. So I'm just going to assume that everything that got pitched and lost was negative for you and goes against you. So now you have a situation where you have put yourself in a horrible defensive position because the court is assuming that everything that you somehow lost or destroyed is negative with respect to your defense. And that's a very, very bad position to be in. From the employee's perspective, what is she doing right now? You're sitting back sort of waiting for stuff to happen. You're preserving evidence. She's out meeting, we'll just pick the EEOC, an EEOC investigator. They're going to take down the relevant facts, and they're going to help her formulate a complaint of discrimination. And really, they help them write it. So they say, hey, what happened? She tells them she doesn't know the concept of constructive discharge, probably. They will educate her. A lot of employers object that this seems biased, that they're actually helping the employee to create the complaint against them. But really, there is some logic to this. So if you think about the big corporations of the world who have lots of resources and all the attorneys they want at their fingertips, an employee doesn't have a chance of being successful against them unless an employee has some help. They don't know the law. They need some help to formulate their complaint. And that's the thought process, is that the investigator is sort of protecting the rights of the employee. And if you have done something really wrong as an employer to poor Janet, then they should help her. and they should help her formulate it and help her be able to protect her rights and go after you if you've done something wrong. So the investigator is helping. They are not a neutral third party. Once they have formulated the complaint and what's known as the request for information, it's then sent to the employer. So this is the first you're going to get it. What do you do with it? Let's assume that you have EPLI. That would be the best thing to assume here. What you need to do is immediately notify your insurer. There's a parade of evils if you fail to do that right away. In your insurance contract or agreement, there is an affirmative obligation to notify the insurer in a timely manner and to cooperate with the defense of the matter. If you're out running around defending it on your own before you ever notify the carrier can say, hey, you have materially prejudiced our ability to defend this and to handle this claim, and therefore we're not covering it. So don't do that. I'll give you the worst example I ever saw of this. A relatively large employer, 600 some employees, got a complaint of discrimination. They got them on a relatively frequent basis, not because they were a bad employer, but just if you have that many employees, it just happens. And they formally did not have EPLI. They bought EPLI. They got some more complaints of discrimination. They forgot they had EPLI. That was a bad mistake to make because they went about doing what they had always done, which is handle these complaints on their own. And somebody along the way within the company, probably 6 months into handling these complaints on their own, realized, hey, why are we handling these on our own? We bought EPLI. We should be handing these over to the insurance carrier. And the insurance carrier got these complaints that the employer had already turned over documents, had already talked with the investigator, in some cases had made offers of settlement. And the insurer just about went nuts and said, forget it. We're not covering any of that because you weren't bright enough to remember that you had EPLI and you did this on your own. We'll cover stuff going forward, but we're not covering these old claims that you should have notified us in a timely manner. And the worst part of that is they had one that went against them to the tune of about $800,000. They could withstand that hit actually, but it would have been much better if their carrier had been on notice in a timely manner and it had been helping them to do this, and then would have been responsible for the settlement payments or the court decision. That verdict was eventually reduced, but still very expensive mistake. So assuming you notify your insurer in a timely manner, the next thing you're going to see is what's called a reservation of rights letter and some deductible information. And this scares a lot of employers because it's a multi-page legalese letter that basically says, hey, you've told us you have a claim. If we ever discover it's not really a claim or not covered within the terms of our policies, we're going to withdraw coverage. And it goes on and on and on in that vein. You should know these are pretty standard letters. The insurer is doing it to protect themselves because they only know a little bit about what you've told them. They don't know everything to date. They don't know for sure that the claim has occurred within their coverage period. Like, did this claim originate before you had them as your insurer? They're just protecting themselves. Don't be alarmed by the letter. You should know what your deductible is already. So that should not come as a surprise either. And you pay first with a deductible. So if you have, let's say, a $5,000, $10,000 deductible, you will blow through that almost immediately with these types of claims. So just assume you're about to write a check. The insurer also assigns counsel. What does that mean? Now, can you pick who your attorney is? Maybe you've had a great relationship with Joe down the street and he's always been your counsel. In most cases, unless you're a very large employer and unless you've had it written into your insurance contract, you can't pick your counsel. They will have a panel of counsels that you might be able to choose from. So you might be able to select one out of 5 firms, or they might automatically send it to somebody. But you're probably not going to be able to select. You're going to have a panel counsel. So what does that mean? Well, let's talk about how a law firm works and how an insurer works a little bit. So the insurer has contracted with a handful of law firms in your area that usually specialize in employment law. Sometimes you get surprised and one of them is just a general practitioner. But the firm I worked at, we were panel counsel. We had a labor and employment department that I was in. We exclusively did management side, employer side, labor and employment law, and we were panel counsel. And the idea is that this can be a bit of a volume business, right? Complaints of discrimination are filed every day, and the insurer needs somebody to send them to. The law firm has agreed to take a reduced rate under the theory that this is a volume practice and they'll get more cases that they can defend that way. So my experience with panel counsel is, yeah, you're usually getting a pretty good attorney who specializes in labor and employment law, which is what you want. You don't want just a general practitioner. And the insurer has arranged for a discounted rate, which helps you with your deductible too. Even though you're going to blow through your deductible pretty quickly, you're still getting a discount, if that makes sense. So that's not a bad thing. Oftentimes, the way the firms work this is they will have a junior associate, that's somebody who's somewhat fresh out of law school, supervised by a partner, somebody who's been around the block more than once, somebody like myself who's practiced for 20 years and has seen a lot, supervising the junior associate. And the reason for that is it gets the junior associate some experience, which they need. And the junior associate, their billable rate is less to begin with. And so the discount from the insurer doesn't hurt the firm as much, if that makes sense. It's a monetary decision. You as the employer should always make sure that you have somebody senior overseeing the case. And the firm, certainly the one I worked with, was very serious about overseeing the case. We don't want a malpractice claim. And so while we might have somebody who's younger and less experienced doing some of the legwork, there should be somebody senior overseeing it and looking at it and saying, gosh, what do we think about this case? How do we think it's going to be viewed by the EEOC? What are our thoughts on this? One of the first things you almost always see too is a request for an extension of time by your counsel. So normally when you get the complaint of discrimination, you have 20 or 30 days to respond, and the request for information, same thing. Usually the attorney will file some type of extension of time. 30 days is pretty typical. And the reason they want to do that is they want to take the time to assess what has gone on rather than being precipitous and just responding to the complaint. So the attorney is the first one who may play devil's advocate with you and request all your documents. They'll want to interview the relevant employees with respect to this. In Janet's case, Janet's the one filing, but we would look at the other people involved, the supervisor, her HR file. By the way, one thing to always remember with employment files, never put medical information in them. Medical information is kept separately. They'll look at that. They'll want to see all the electronic communications, all the emails, including the stuff on the BYOD, bring your own device. They'll want to know if you've preserved evidence. They are assessing the strength of the case because ultimately that attorney answers to both you as the employer, you're their direct client, but they also want to be honest to the insurer and say, hey, I've met with this employer and, this case is strong, it's weak. I think we should settle. I think we shouldn't, whatever it might be, they're assessing it. What if the attorney wants to settle? What if they look at this and say, oh my gosh, this is horrible. You employer really missed the boat and you disagree. Because oftentimes these cases are highly personal and the individuals involved are offended because they can't believe that Janet said they would discriminate. What if you disagree? If you have insurance and the insurer wants to settle and you refuse, you have a problem because the insurer will say, well, we were willing to settle for $10,000. So anything above that, If we get dinged for more, you're on the hook, not us, because you wouldn't follow the policy terms of cooperating. And therefore, when we were able to settle this for 10,000 and you refused, you're on your own from here on out. That's a bad place to be. You have to cooperate with the insurer, even if it really rubs you the wrong way. All right. What if you don't have EPLI? I hope this is far and few between there, but the first thing you need to consider is counsel. I highly recommend it. You can sometimes tell if the employee has counsel because sometimes that her attorney's been helpful enough to draft the whole complaint and we'll send it to you. If they have counsel, then I would argue even more strongly that you should get counsel yourself. But let's say for whatever reason you can't afford it, you don't want to, whatever it is, think about who responds for the company, because you're going to verify or attest to the answer and the documents and the facts that you're submitting. And oftentimes you're relying on information from other people. So in Janet's situation, it's probably not the HR manager who should be attesting or verifying the answer. It's probably the owner of the company or the president or somebody like that. But you're relying on the information from the HR manager and the supervisor and other people, and you're saying, hey, this is true, sort of under penalty of perjury type of idea. So you have to really have faith in them and be sure that you feel good about this. You also have to be careful what you provide, because you don't want to open up another can of worms. Agencies are great at sharing information. So, if the EEOC discovers you've got a wage payment issue going that you have unwittingly or unknowingly revealed while you're trying to defend the complaint of discrimination, they're very helpful in calling up the Department of Labor Wage and Hour Division and telling them that you have a wage and hour problem going too. And the other thing you should think about is an extension of time. Don't race through this. There's good reasons to get an extension of time, to get your documents together, to consider counsel, for your own internal sort of looking around and seeing what happened, investigation, to make sure that you feel comfortable about what's happening. What about mediation? So in the complaint that you receive, there's often additional paperwork that says, hey, the EEOC has a mediation program. Are you interested? Are you? If you have EPLI, your counsel is going to make that decision for you, and it will depend on how good or how poor your case is and what they think about it. There's good reasons to do it, but there are some downsides to it. It's inexpensive. It's free. You're not paying a mediator. It's the investigator or somebody in the office of the EEOC or the PHRC who's doing this. They are running the mediation. You're not paying a mediator's rates. Most mediators are attorneys, so if you paid a private mediator for this, you've got more fees involved. It's cheap, but it may make you ill to settle with somebody that you don't think deserves a dime. That's absolutely true. These cases are personal. But if you're sitting there and saying, I don't have a safety net, I've just been sued, or you have some facts that are really poor for whatever reason, this may be the time to settle, because we know statistically 98% of all cases, not just employment cases, but all cases settle before trial. It's a question of when they settle. How much have you invested into the case before it settles? If you're at this stage where you have just received the complaint, you have invested almost nothing, right? Very little into this. Okay, is mediation the same thing as conciliation? Conciliation is usually done with the courts. Somebody asked this question. Good question. So conciliation is usually done with the courts. They are very similar processes, very similar. Sometimes with conciliation, you have what's known as a neutral individual involved. Like if you have early neutral resolution of these cases, when you get to court, you don't have the investigator who might have a little bit of a bias or a little bit of a dog in the fight who wants to resolve this and get it off his desk or her desk. But very, very similar to conciliation. So thank you for the question there. So we know 98% settle. It's just a question of when, how much have you invested, and what happens. For those of you who think about, well, I want my day in court, usually prior to getting to court, the judge is going to pressure people to settle because it gets it off their docket. Their dockets are swamped. Yes, they will give you your day in court, but we know only about 2 or 3% of all cases actually go to trial. Okay, so what happens at the mediation? So typical mediation, each side brings counsel, perhaps, if they have it, and you sit in different rooms. Sometimes you start off together, but you sit in different rooms eventually, and the investigator shuffles between the rooms and says, you know, they try to be honest, which sometimes it's good to have somebody reflecting back to you the negatives about your case or the positives, because they're doing the same thing to the employee, and say, well, gosh, you know what? Janet had positive reviews for the last 20 years. That's, you know, looks pretty bad for the employer, because if she really was an attitude problem, why weren't you honest in the reviews? And most employers hate being blunt in a review. And so they tap dance around the problems. And so sometimes the employee reviews are not as blunt as they should be, and they reflect a much better employee than you actually had. But that investigator will reflect back to you what they think about things, and you can reflect back to them, hey, you're not hearing the whole story from Janet. Janet said blah, 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 but you should know that before she left, Janet punched somebody, or whatever it is. Okay. In this case, Janet didn't punch anybody, but that's the type of stuff you want to convey. So the complaint, let's say we haven't done the mediation, we've just got the complaint sitting there. It usually looks like it's numbered paragraphs that you have to respond to, and it makes a request for certain documents. So how do you respond? If you're at the EEOC, we have some flexibility, and if you have counsel, they will know this. They will also know who your investigator is, because it's a small world. They'll also know any preferences that investigator has, and they'll also know if that investigator maybe leans in one direction or another on certain claims. Maybe that investigator has a soft spot in their heart for gender discrimination or whatever it is, or really is difficult to deal with, or whatever the quirks of the investigator may be. That's the advantage of counsel too. Assuming you have a specialized counsel, they will know. So for the EEOC, the typical response is a position statement. It's a narrative letter saying, hey, Janet told you X, Y, and Z, but let me tell you what really happened. It's ABC. And then you attach the relevant documents, which typically is not everything that the EEOC asks for, because they tend to ask for the kitchen sink, because Janet has told them that everything since day one, when she started 20 years ago, is relevant. We're not attaching all of that. We probably are attaching her employment file and some things like that. The PHRC, if you're in Pennsylvania, has an answer or has a complaint that you actually have to answer paragraph by paragraph. So you will say admit, deny, or denied as stated, and then reflect what you think about things. That's a good reason to have counsel if you've never responded to a complaint before, because that's what the PHRC is looking for. And they're looking for somebody to essentially sign off on that complaint and say, hey, I've done a reasonable investigation, and this is sort of like subject to perjury type of idea. I'm verifying, I'm attesting to this, that this is all true. And you're going to attach a document, some documents again. So what documents are you turning over? Well, again, like I said, it's unlikely to be everything the EEOC or the PHRC asked for. You want to consider privilege. And if you have counsel, they're making this call for you. So you basically do a document dump to your counsel of anything and everything that could be relevant. Don't hide stuff. No attorney likes to be surprised. And that's a huge issue too. Don't do that. So you may have some privileged documents if you talked about Janet's situation with counsel, either before or after she stormed out. You want to consider privacy issues. Oftentimes the EEOC asks for pay comparisons if it's an equal pay type of situation. Disciplinary comparisons. Janet said you treated Joe much better. You never disciplined Joe, but you disciplined Janet, 20 times. Joe's records are private. His name, his numbers, his address, if they're asking for things like that, and oftentimes the EEOC will ask for things like that, we may raise a privacy objection. We're not giving out our employees' personal information. It may be interesting to see who the EEOC is asking about as comparators for our own purposes as we defend the lawsuit, but we have a privacy obligation to our own employees not to just hand out everything just because the EEOC asked for it. So we may redact documents and do things like that. And again, that's why you should have counsel, because they will help you make these judgment calls. Then what do? Okay, you can go to lunch. You get to sit back and wait. The investigator basically takes information back and forth. So now you've sent in your position statement. He takes it to Janet and basically says, hey, Janet, you said XYZ, the employer is saying ABC, what's your response? Undoubtedly, Janet has a response and Janet will come up with something. And so then he or she, the investigator, will take Janet's second response back to the employee and say, well, you said ABC, but Janet said DEF. What do you think about that? And this will go back and forth. I have seen these cases last into the years. So not just months of going back and forth because the investigator has a huge caseload, they're overwhelmed. And they're shuffling information back and forth. And so I never saw cases get resolved in less than about 6 months. And by resolved, they're really not resolved. We'll talk about that in a second. But this doesn't just happen overnight where the investigator comes to a decision. This goes back and forth and back and forth. And we had cases that were over 1 or 2 years old that were still going back and forth. You may also be invited, and by invited, it means compelled, basically, to an EEOC fact-finding conference. If you don't have counsel, reconsider that at this point. Something is not right that they want you at a fact-finding conference. They reserve that for cases that they're really looking at because they don't have time to hold fact-finding conferences for every case that comes down the road. If you get invited to one of these, it means something is up, and either you don't know about some bad fact out there or something has occurred. So be very careful of these fact-finding conferences. What's the result? You've gone back and forth. It's been months, probably been 9 to 12 months on average that this has gone on. You will get a letter from the EEOC or the PHRC or whoever, and it has basically 2 options on that letter. It'll either say there's probable cause. That's awful. So probable cause, you have a big problem because the EEOC has decided that there's probable cause that the employer discriminated. And that means either the EEOC itself will take the case or counsel will certainly take the case, because if they have a probable cause letter, they'll be jumping up and down for joy because they can show that to the court. Or you'll get a decision that basically says, can't tell, sort of like he said, she said. There's no exoneration for the employer. You never get a decision saying, hey, we think the employee lied outright and employer, we're so sorry this happened to you. It doesn't happen that way. So you're going to get a letter. Hopefully you've got the sort of I can't tell result. And what gets issued with that is what's known as a right to sue letter. They send that to the employee. That means the employee can finally sue you in court. So she threatened 9 months ago, I'll see you in court, but she couldn't do that because she had this whole administrative prerequisite to get through first that you have spent a lot of time and money on. And now she's free to sue you. And guess what? It starts all over in court. So regardless of the result, the employee is free to sue you in court and you start all over from scratch. So all that money that you invested in attorney's fees and time and gathering documents, yeah, it's valuable. It'll go towards the court proceedings. You'll reuse that information, but you're starting from scratch. So let's go back to Janet a second. And again, if anybody has any questions as we go on, please feel free to ask them. Janet's supervisor in this case was a female, same age, same race. Does that stop Janet? No. Those are good facts for you to have because it's unlikely that somebody who's the same race and age and gender will discriminate against somebody who looks exactly like them, for lack of a better way of putting that. But it doesn't stop the lawsuit. We often have lawsuits come in where the supervisor who made the decision or the HR person who made the decision looked, for lack of a better way of putting this, exactly like the employee. And you said, well, gosh, they're the same race, same age, same whatever. Doesn't matter. No, that lawsuit still goes forward. It's a fact that's favorable to you, but it doesn't stop it. So in real life, Janet had an altercation at the copy machine. This is actually very truthful. I didn't change the copy machine part because as an employment attorneys, we sometimes enjoy the facts and just the way this played out. So Janet's executive boss, she worked for a certain person, needed copies right away. Someone else was at the copier. Apparently, Janet missed kindergarten in the idea of waiting in line. She didn't feel that she could wait and told the other person in no uncertain terms that she needed to make copies. No profanity, just terse. And remember, Janet's been an attitude problem for the last 20 years. She has no fingertips, never has. The other employee spun around and told Janet no in a loud voice and that she wasn't a dog to Janet. I'm not completely sure what that means. I never have been completely sure what that means. But essentially, she was refusing Janet's request. Janet claimed the other employee was poised to physically attack. She feared for her life at the copier. Yes, it was the showdown at the OK Corral copier. Hey, if you don't laugh, you cry, right? So the secretarial supervisor ran in to tell them both to cool their heels and told Janet that she has always needed an attitude adjustment and was going to HR to have her fired. And that's when Janet stormed out. This settled for about $30,000. Anybody surprised at that amount? Or that it settled? Why did it settle? I wanted to hear shock and awe here in the comments, but I'm not hearing it. Here's why it settled. So they had EPLI. That was one issue. The second issue was they did nothing about the other employee who was very loud and somewhat aggressive back towards Janet. They also had no employee review documentation showing that Janet was an attitude problem. You would think in 20 years, if she was that bad of a problem, somebody would have documented it somewhere, but they didn't. That looked a little fishy. Then they got invited to an EEOC fact-finding conference by an investigator who may have had a certain soft spot for certain types of cases. This company also had the foresight to look at this as a business decision. One of their great concerns was their reputation in the community. They were a service provider that prided themselves on treating people right. That was sort of their slogan in life. They did not want it to make the news that they had an employee that was suing them for discrimination. They wanted to settle no matter what. That was their call as the employer. And the insurer was on board because the insurer thought there were some holes in this as to how it was handled, and especially those employee reviews. Also, they gave bonuses to Janet. If you have a problem employee, you don't give them a bonus. A bonus shows good work, right? Even if it's the holiday bonus and you're giving everybody a bonus, don't do that. If they're a bad employee, exercise your right to try to nudge them out the door with a bad review and not awarding them anything for performance if they're an underperformer. So this is settled for a whole bunch of reasons, but those were the primary ones. Let's talk about a couple other cases. So 5 years ago, we had a supervisor who entered drug rehab on a last chance agreement with the employer. For anybody who doesn't know what a last chance agreement is, basically he had screwed up at work so badly because of his addiction that the employer said, look, you're otherwise a good employee. We know you have an addiction problem. We're willing to give you one last chance. And if you go to treatment and show that you've gone through all these hoops of a treatment, you can come back to work with us. He did all that. That was great. This last chance agreement worked out well. He was a great employee for them. He continued to work, no discipline. He unfortunately engages in an unsafe practice that was against all of their rules with another employee. They both did the same behavior. The supervisor gets fired, the employee's retained. They don't do any discipline to the employee. The supervisor sues for disability discrimination because he has a known history of drug discrimination. So if you have a known history of something, of a medical condition, that is a valid basis for a discrimination claim. The employer wins the case. I will tell you, this employer had about 200 employees. They did not have EPLI, but they had the financial wherewithal and a president who had a backbone, if I can put it that way, who was like, I am not paying this guy a dime. That's one of our biggest safety rules. He broke it, not doing it. We had him for 5 years after we knew about the drug issue. He was a great employee, but he did this to himself. They went all through the agency level. The employee sued in federal court. We went clear up to what's called summary judgment. The court decided in our favor. The company was willing to invest, 150, 200,000 in legal fees to win because they didn't want to open the floodgates. And they felt very strongly that this guy didn't deserve a dime. They had the backbone and the financial wherewithal to do that. Okay. To the employee, next case, the employee is caught on a security camera, allegedly stealing meat from a nursing home freezer. He is terminated. He sues for race discrimination. It's settled for $2,500. Why do you think it settled that cheaply? He had a horrible case. He's on video. Now, granted, the video was very grainy and it was a little difficult to even identify him. But his counsel knew that this case was a dog with fleas and the fleas had fleas type of thing. They were willing to settle cheaply. This was less than the employer's deductible by a good bit. This was a large employer. They had like a $50,000 deductible. And they viewed these things not as a personal affront, but as a business decision. And this was like throwing peanuts for them to somebody to just go away. Everybody walked away happy. It is what the employer wanted to see happen. They didn't buy into the prior employers, the guy with the drug addiction. They didn't have that mentality of, I will never pay him a dime. He doesn't deserve it. They viewed it as a cost of doing business, that they would get frivolous claims. All right. We have an employee, a CFO. He does not get along with the new president of the company. He's been the CFO for more than 20 years. No disciplinary action. They are the same age, race, and gender. What happens? The president hates the CFO hates the president. It's not going to work out, right? Well, let me throw this out as sort of final food for thought in all this. Nothing happened. The president said, look, this is just, we're not on the same page. I'm offering you a severance package because you haven't done anything wrong. You have provided 20 some years of loyal service to the company. And I recognize that, but you're just not the right fit for somebody who's on my team. And really the president should have their own team, right? When you're looking at these things and you're the owner, the president, or whoever, you want your own team. This guy was not part of that team. They came to an amicable agreement. They had a severance agreement. Nothing went anywhere. The only reason we were involved is because we drafted the severance agreement. So always think about that as an option, particularly when you have difficult cases or cases where you say, gosh, it's not that the person's such a bad person or they really haven't done anything wrong, but they're just not the right fit. They're not the person we want on this team. Maybe a severance is the right way to go. All right, I thank all of you for attending. Feel free to ask any questions here if you have any here at the end. Next month, we are going to go back to the FLSA because it seems like you guys can't get enough of the Fair Labor Standards Act. And we're going to talk about what makes a person exempt or not exempt. If you guys have ideas for seminars in the future, please feel free to pass them along. I love the ideas, happy to try to incorporate them into the seminar. But so for November, we'll talk about the administrative, executive, and professional exemption, the duties test and the salary basis test, and what makes somebody exempt or non-exempt for purposes of overtime. Okay, it looks like we have a couple questions here. I'm glad you enjoyed the training. Really, I love doing training and I enjoy it. I just wish it was in person and that we didn't have COVID forcing us into a webinar. 2 people have asked if we'll share the deck or the slides after this. Yes, everything gets posted. Give us about a day to post everything, but it does. This whole seminar gets posted to the CTR website. So absolutely, you'll have access to all this. Just give us a day or 2. If there's any other questions, please feel free right now. Otherwise, we will end this and hopefully everybody will enjoy their lunch. Okay, I'm not seeing any other questions come through. Everyone take care. I'll see you next month.